Okay, so I think we have started. Everybody ready? Okay, good afternoon, everyone. Can everyone see my screen? Yeah. Okay, good afternoon and a warm welcome to today's webinar. My name is Emmeline and I'm from Landlord Vision. I'll be your host today, and we have a genuinely important session lined up for you today. The Renters' Rights Act is now law, and for landlords, it represents one of the biggest shifts in how tenancies work in a generation. Whether you've been following it closely or you're still piecing together what it means for you, you're in exactly the right place. Now, for those of you who are new to Landlord Vision, we're a property management software platform built specifically for UK landlords. We help you to manage your properties, finances, tenancies, and compliance in one place. And with record keeping and documentation becoming increasingly important under the new legislation, that's something we're very focused on right now. Now, before we get into it, just a few housekeeping points. Please do keep yourself muted throughout. The chat and the Q&A panel are open, so feel free to use those for your questions as we go. We'll have a dedicated question and answer session at the end, so do save your bigger questions for then. They do keep them coming through throughout the session so that we can collate them for the end. Also, we're recording today, so if you need to step away, don't worry, you'll receive a link to the recording afterwards. So here's what we've got lined up. We'll start with a short scene setting conversation to ground everyone in what the Act is actually doing. Then we'll move into a longer in-depth interview covering the immediate obligations, dispute resolution, and what landlords should be doing right now. This is the heart of today's session, and we've given it plenty of room to breathe. After that, Roy from our product team will give a quick live demonstration of how our Landlord Vision software will help with the compliance, and we'll finish with a live Q&A at the end. So let me introduce the people that you'll be hearing from today. Our guest today is Sean Hooker. Sean is the head of redress at the Property Redress Scheme. And one of the leading tenancy deposit and redress schemes he's going to talk about today. He's been at the centre of landlord-tenant dispute resolution for years, and there's nobody better placed to help us to understand what this legislation means in practice. We are very lucky to have him. And Roy from our Landlord Vision product team will be joining us a little later to show you how the platform works in action. Before we bring Sean in, I'd love to ask you a very quick question. It'll help us follow up with you more usefully after today. So I think we're going to run a short poll. If you see it pop up on screen, please do fill it in and have a go. So, yeah, some people responding, getting those in. That's great. Lovely. Okay. So, Sean, let me just move that out of my way. Okay, so I've stopped sharing my screen now so we can focus on Sean. For anyone who's been hearing about the Renters' Rights Act but hasn't fully got to grips with it yet, what is this act doing, and why should landlords be paying attention right now?
Thank you, Emmeline. Good afternoon, everybody. Happy St. George's Day, patron saint of England, which is quite poignant because this legislation applies only in England. So if you are in a landlord in another jurisdiction, Scotland or Wales, this doesn't apply to you. You're in the wrong place at the moment. You might learn a few things about how we're going to do things in England, but it's a different thing. Yeah, so this is the biggest bit of legislation that landlords and letting agents, in fact, the whole property letting industry has experienced for almost 40 years now, I would say, since the Housing Act 1988. There have been a lot of other legislation in between this, but this is the biggest radical change in the way that you're going to actually have to deal with your tenants ongoing. And effectively, there's two major parts. One is, the one that's been most publicised is that Section 21, the no fault eviction process, is being abolished. But fundamentally as well, your tenancies are all going to change from fixed term to periodic. So that literally will be the act has been passed, so it is law, but the implementation period is literally going to be at the end of the month. So 30th of April will be the last day that Section 21 and fixed term tenancies will be a legal mechanism. From the 1st of May onwards, you're in a different world.
Great stuff. So question 2, a lot of landlords we speak to are feeling quite anxious about these changes. From your position at the property redress scheme, is that anxiety justified, or are landlords overcomplicating this in their heads?
That's a very good question, Emmeline. And yes, I mean, look, of course, this is a major change to the way that you're operating. And yes, if you weren't anxious about it, then there would be something wrong. So you probably don't know enough about the legislation to understand the implications. But to be worried about it and feel it as is a threat, that's a different matter. This is, for most of you out there, May the 1st things will not change the way that you fundamentally run your businesses. You will still be renting out properties. You will still have tenants. Those tenants will still have needs. They will still be paying rent. There will still be obligations on them to look after your property. There will be obligations on you to look after them within the property. But there are things that you need to be aware of, and you need to change and adapt to make sure that you understand them and that you are protecting yourself as well as your tenants.
Great. So nothing to worry about, nothing too onerous to worry about anyway. Okay, so let's start with what's most urgent. Every landlord with an existing tenancy has to serve the government's information sheet to their tenants by the 31st of May. Have I got that date right?
No, yeah, by the end of May, yes, yeah.
So what happens if they don't, and what are the most common mistakes that you'd expect to see?
Well, look, the first thing you have to understand that the information for tenant leaflet is being sent out is to explain to your tenants that their world is also changing. Your world is changing, but so is theirs. So they need to understand that the contracts that they signed with you, okay, and that might have only been a few weeks ago if you've taken on a new tenant, they are going to fundamentally change from being fixed term. So if it was a 12-month or 6-month or 12-month or even a 2-year contract, that will be non-applicable, and therefore after that it will be a rolling tenancy. They need to understand that, and they need to understand that the way that they can be asked to leave a property, the way they can give notices to leave the property will also be changing. That's all in that leaflet. The government, of course, says, well, actually, you are the ones obliged to send them that leaflet. They're not going to post the tenants, every tenant, one of them. You're going to have to do it. So like anything where you're obliged to do something, there will be a consequence if you don't. And that consequence will be if you do not serve that notice within that 31-day period. Is it 31 days? Yes. Then you will be liable for a fine of £7,000 for the offence of not serving that notice. If you then, after 28 days, persist in not sending the notice, and remember, this is for every tenant. So if you've got 4 tenants and 4 properties, there's 4 fines. Okay. If you don't serve it after that 28 days after being given the notice of the penalty and to serve it, then you will be liable. Could be liable up to £40,000 fine. So look, there's a big stick over you, but it's a simple job. Okay, number one is that you've got to send that notice out. Number two, if you have an agent, even if you send it out, they should send it out as well, just if they're acting as the first call. don't rely on each other. Both send it out. Okay, you can send it out in one of three ways. You can hand it over personally. If you do that, then make sure that they sign that they've received it. If you can send it by email. Okay, but again, make sure that there's an audit trail for that, or you can post it. And again, if you're going to post it, it will be deemed served. But remember, proving that that you've posted it is the most important thing you could do. What you can't do is basically signpost them to the link, or just send them a link. You need to have actually sent them a physical copy of, or a virtually physical copy, if that makes sense. So it's a relatively simple job, but of course it's like everything else. There's the logistics of actually making sure that you've identified your tenants, you've got the best way of contacting them. Double check your tenancy agreement on how you are permitted to serve notices. Some older tenancies tend to have kind of one saying that only by physical or by post is valid. Otherwise, you can serve it by email. So just double check that, and also double check if you've got an agent that they're doing their job as well.
Okay. And sorry, just on that point then, so you're sending these out, are checks made that you're sending them out? You know, do you need to keep receipts or postage or an email log?
100%, yeah, 100%. It's like anything that, if you correctly serve it, so serve it right, or it serves you right. That's the motto there. Make sure you follow any procedure that you're sending for a serviceable document. So you should be having a protocol for doing that anyway. So yeah, keep your audit trail, because you will get tenants saying I haven't received it, or if you've got an HMO and you've posted it through their pigeonholes, they say, oh, somebody, I didn't receive it. So make sure you have an audit trail, because that's what the evidence, if they go to local authority and report you, the local authority will be asking you to prove, okay, that you have sent it. So make sure that you've got that audit trail in place.
Lovely. I did just see a question pop up there, and just because it's pertinent right now, someone said, what would you put in that letter?
Well, the information for tenants leaflet is there, and that's the document you serve. So literally,
okay, so you wouldn't need
download
to
it
add
on.
anything else.
We don't need to add anything else. I mean, look, between you and I, and look, we've got a lot to get through. The government just wants you to have proved that you have served that document. In terms of your service, I think it will be in your interest to have conversations with your tenants at some stage during that month, as well as serving them that notice. They will be sitting there, you'll be ringing up and say, well, I've received this from you. What does it all mean? Because like, tenants might not have it's written in simple English, but they might not understand the whole nuances of it. They may have difficulties in understanding the document. Maybe their language, the first language isn't English. So I would be kind of having that conversation and trying to explain to them that you're going to have, by legally serving this document, that it's changing. These are the changes that are coming in there, but have that conversation. It's a good opportunity now to open a dialogue with your tenants. So yeah, if that means an accompanying letter, or you literally give them a call or whatever, do whatever you feel is the most appropriate to make sure your tenants are in the best position of doing it. What you don't want is that, you, even if you've done the right thing and served it, that you don't want inquiries to be made and you've been distracted by the local authority ringing up and saying the tenants rung up and said they haven't received it. You've got to make sure that you're protecting your back on that one.
Yeah. Okay, so from the 1st of May, all tenancies become rolling periodic tenancies, and Section 21 is gone. I think you mentioned that before. Yeah. For a landlord who's been relying on fixed terms and Section 21 notices to manage their tenancies, what does the day-to-day management actually look like now?
Well, I think there are going to be certain sectors where it's going to affect you more. One of the areas that was one of the biggest debates was the student let market. There have been compromises and provisions being put in to try and overcome what is a big concern about by student landlords, that their tenants won't leave at the end of their academic year or term. But for the rest of us, it's about understanding that most tenants don't move into a property and then immediately want to move out.
Mm.
If they move into a property that isn't really very nice and there's broken stuff there, then of course they want to move out. And one of the provisions now with a rolling tenancy allows them to only give you 2 months notice and be gone. You know, but if you provided a nice home for a tenant, they will want to leave when they want to leave. So I would have a conversation with your tenants ongoing about how long they would like to stay. So we can't commit you to contractually to that, but the understanding is that, you know, as long as we're both happy with each other, we're in a long-term relationship, and that doesn't change, because essentially I will only ask you to leave if my circumstances change, and not because I want to get you out. And as long as you abide by the rules and regulations under our tenancy agreement and don't break those terms, i.e., you treat the property in a decent manner and you pay your rent and you're not being a nuisance to everybody else and your fellow tenants and the neighbours, then I won't need to take any action against you. So that will, for most of you, will be business as usual. It will change, of course, for those hard cases. And of course, a lot of landlords will say, well, what happens if? Well, of course, you've got to make a different now provisions to make sure that you are protecting yourself. We can explore that a little bit later. But it doesn't happen very often. Most landlords and tenants want a long-term relationship, and they want, a situation that suits them.
Great, thank you. So from that to rent increases, so now they have to go through a Section 13 notice. What should landlords be aware of here, and what does a defensible rent increase look like if the tenant challenges at the first tier tribunal?
Absolutely. Well, the Section 13 has always existed. It's just a lot of landlords didn't use it because they used to put in rent clauses into their tenancies, rent increase clauses, or they actually just negotiated them separately. This is now changed. Every single rent increase that you want to make has to go with a Section 13 notice. You can only do it once a year, and you have to inform the tenant that if they disagree with it, that they can appeal it. Now, the appeal process, there was a lot of debate in Parliament about the appeal process. At the current moment, you can go to a tribunal. The tenant the tenant can ask for the rent to be reduced, but the judge can now turn around until the 1st of May. The judge could turn around and say, well, actually, I agree that the rent should be increased, and even no, not only do I agree it can be increased, it should be increased to the market rent, which is more than the landlord's actually raising it. Mm-hmm. From now, from after the legislation goes live, the judge will only be able to reduce it and or keep it the same. They won't be able to raise it. The problem is going to be that whilst there is a hearing pending, the rent increase doesn't kick in. So you really don't want it to go to a tribunal, because it could take 2, 3, 4 months, and the rent increase is only applicable after it's been sanctioned off by the tribunal. So I would say ongoing, what you need to do is to have conversations and feel out the tenants about what is a reasonable rent increase. There are ways you can do to actually look at market rent. And I'm gonna make a plug, but I'm not, because I don't. I've only just seen this new product, but there is a product out now that is literally collating market rents across the country from a various different sources, and you just basically can have a look at what a typical market rent would look at. when you go to a court, all the court will look at and say, well, actually, hold on, what, are you charging the right market rent? What is the evidence that you've got for that? So at the moment, you can go on and look at Zoopla or Rightmove and have a look at typical rents. You can have a look at what the VOA information that's out there. You can have a look and see, well, actually, yes, this is a typical rent for my area. I'm not overcharging. If you have extras and things that are features that you believe make your property more valuable and a higher rent, you've got to evidence that. So if you basically all you put in is I've got a 4-bedroom house on Little Whitting Street in Birmingham, then all the evidence that can be looked at is basically what's a typical rent for that. But if you've got a jacuzzi and free Wi-Fi or whatever the service is, so make sure you put out what your proposition is and why you think that rent would be higher than the typical rents.
Perfect. Yeah. So like an itemized rental invoice or receipt at the end showing what that breakdown
Correct.
would be.
Correct. Yes. Yeah. It's all evidence based.
Yeah, all evidence based. So that leads us on actually to what, if something does go wrong. The new private landlord ombudsman is coming later this year. Can you give us the insider view? What will this ombudsman actually do, and how will it be different from what property redress scheme handles today?
Right, so I've literally just come off a meeting with the government. I can't disclose. I'm under confidentiality. I can't disclose the kind of the conversations that we've had there. But the general principle is this is a separate ombudsman that every landlord will have to join, even if they're using an agent. So if you're using an agent, that agent will be registered with us or the property ombudsman, but you will also separately have to register. And ultimately, the tenant will be allowed to raise a complaint against you with that ombudsman. Ongoing, whether you'll be able to do that through your agent or there will be two separate issues. That's all up for grabs at the moment. So there's a lot of detail in there, but the governments are looking at the most simple way of delivering this, and that is literally to have not multiple ways of entering for the tenant to enter in, but one single way. So the more the more details will come out as it goes along. But all you need to understand is that probably by the end of 2027, early 28, there will be a database in place. There will be the provision for you to join an ombudsman, and you will have to be responsible for making sure that any complaints that are raised with them are dealt with in the most appropriate way. So yes, it is something to expect and to plan for, but don't panic at the moment. It is not the most important thing that you need to worry about if you are phasing. If you're phasing in and breaking this down into the bite-sized pieces you should do in order to comply.
Okay. And when a tenant complaint reaches you at the PRS, what are the most common things landlords have done wrong or failed to do that weaken their position?
Okay, so because we're dealing with your agents, it's normally that the agent service or communication hasn't been put in place. However, agents are only acting on your authority. So one of the things that we see commonly at the moment, and literally we can't deal with because the agent isn't responsible, you are, is if there's a disrepair issue and you have not agreed with your letting agent that works need to be done, i.e. you decided, well, actually, no, I'm not paying for that. The agent can't do it on your behalf. They don't have the authority to do it. So ultimately, this is what the landlord ombudsman, the gap that they will fill. And at the moment, we're very frustrated at the moment because we have to say to the poor tenant, it's not your agent's fault, it's your landlord. And you have to go to the local authority, you have to go to court. And they get very frustrated with it. So hopefully, this is a really positive thing that you will close that loop and that the tenant is protected holistically, but also you as the landlord are protected, because at the moment, you are relying on your agent to provide and implement your instructions, and if gaps appear there, then we can pick up redress for you. Ultimately, it may end up that the scheme, we end up dealing with more landlord complaints than we do with tenant complaints, and the tenant ombudsman deals with them. That's ultimately probably something that will benefit, and really, so literally will be your ombudsman landlords, and the tenants will go to the other one. But I can't kind of say what the final model is going to look like at this stage. But that's the logic of it, to be honest.
Yeah. And with the new framework, what kind of evidence do you think the ombudsman will want to see from a landlord? If the landlord came to you and said, "What records should I be keeping from day one?" What would you tell them?
So it's like everything else, and it's not just for the ombudsman. It's for the deposit schemes. It's for it's for well, even it's now even the tax man. You need to keep extensive records, and those records would be a condition of a property, an inventory. Make sure that you've got all repairs that are done, are invoiced and recorded, from your protection point of view, that there is a comprehensive rent records that make sense, that you can actually follow. Just literally document everything. Okay, if you struggle with that, and I'm a bit like that, my paperwork's all over the place. Get a system that helps you manage it, and that could be something that Landlord Vision might be able to help you with. There are other, platforms out there that help you to do it, but documentation is important. Just the last thing on that is just to make sure that you understand that if you are holding documentation, you are bound by GDPR, and now what's the DMCC. So make sure that you have the right protocols for handling that data confidentially and appropriately.
Okay, so the Act introduces a right for tenants to request a pet, and landlords can't unreasonably refuse. This is generating a lot of questions from our users. From a dispute resolution perspective, what does unreasonable refusal look like, and how should a landlord handle a pet request to protect themselves?
Well, I think number one, you've got to remember that there is a perception out there that pets cause disproportionate damage to properties, and there is some evidence that that a bad pet can cause a lot of damage to a property, but no more than maybe children do, or even students, or whatever. That's why looking at and just having a blanket policy saying no pets is being outlawed. It doesn't mean you are forced to take a tenant with a pet if it is not appropriate for that property, or the occupants of that property, or there is a legal reason why you can't keep a pet. So, for example, the easiest one now is you are living in a flat. The flat has a head lease. The head lease specifically bans pets. That is a legitimate reason not to accept a pet. You could have a situation in an HMO property or a shared property of some description where one of your existing tenants, or one of the tenants, is phobic or allergic to a pet, and therefore it is not appropriate to have a pet that would aggravate that situation. It is also appropriate to look at a property and say, yes, a pet might be appropriate, but not all pets. So, for example, if you live in a flat, a small domestic cat that I think they're called house cats now. They're ones that they never seem to go out. I've never heard of that in the old days, but there are these cats that are perfectly happy. If you put them outside, they go absolutely crazy. That sort of pet is manageable in a flat like that, but not a massive dog that needs exercising on the top floor of a 40-story building. Even if the head leaser permitted that, it's not a practical one to have there. But it's about actually giving a genuine reason for why you cannot take that pet, and to evidence it again. And if there's a legitimate reason, no one's going to force you to have a pet in the property that's not appropriate.
Yeah, good, thank you. So tenants can now challenge eviction more robustly, and landlords need to prove their grounds. Where do you see the biggest risk of disputes arising under the new possession grounds? Is it sale of property, or landlord moving in, rent arrears, antisocial behaviour, for example?
I think, yes, I think this is the situation now, is that the default now is that tenancy will continue on until the tenant decides that they no longer want to live in the property, and then they will give you the 2 months notice. Ironically, if you've got tenants under periodics at the moment, they only have to give you 1 month's notice. You've got the protection now of an extra month, but it starts from day one rather than when a property goes into a rolling periodic. So the ones that have been most controversial in my view are, number one, selling under property, which is a legitimate reason for asking a tenant to leave your property because you want to sell it, but what the government has introduced into it as a well, of course you're going to say, and then the next minute you're going to relet it. You're going to say, oh well, the sale fell through. There's a prohibition now for a year after you announced to a tenant that they must leave because you want to sell the property. There was a prohibition for a year now that you can't relet it. So what you can't do is say, well, if I just say, oh, I'm going to put it on the market, I put it on Zoopla for a couple of days and then take it off, and then I can relet. No, you can't do that. The same applies for moving in relatives and stuff like that. There will be or you're going to move back in. Of course, there will be circumstances where you may not be able to move back in, but there is a prohibition now to stop you from reletting. That will mean that you just can't use these grounds as a mechanism just to get the tenant out. To me now, however, the big one, okay, will be the arrears. And the reason I'm saying that is that at the moment there are two grounds. Well, of course, there's a Section 21, and a lot of landlords, and this is the problem. I don't think landlords would be using this as as just a way of getting rid of tenants. I think a lot of landlords use Section 21. No, I know a lot of landlords use Section 21 because it was an easier route to go down to get rid of a bad tenant, and that bad tenant is one that wasn't paying his rent. Okay, rather than go through court, you could serve the Section 21 and then say, look, they walk away. Now you will have to go through one of the arrears grounds, and they are more onerous. So you literally have a longer period now to, for rent arrears and notices, which we'll wait to see how that pans out. The government's reasoning for doing this was that basically they wanted an extended notice period because it allows the parties to negotiate and maybe save a tenancy that could be saved. The argument I've said to them, and other people have said to them, well, yeah, but literally a lot of those tenancies, it's not fair on the tenant. The tenant literally can't afford to pay the rent. So giving them the chance to stay in is only going to, lead to more arrears, and they're going to end up with me taking a money action against them, and getting a CCJ against them, and I'm going to lose out on another month's rent. Surely the idea would be to just kind of like part company and free the tenant to go and find a more affordable way of living. The government, he said that they will review this after a year or two, but it is what it is. So it is more difficult to get rid of you guys with arrears. What I would suggest as a way of trying to mitigate that is to try and engage in mediation and other ways early as possible, and see if you can get a solution to get your tenant to see it's in their best interest to move out and find alternative accommodation earlier. And the other one is antisocial behaviour. Again, a lot of landlords were serving Section 21s because they had a problem tenant, and it was the easiest way of getting rid of them. Now you are going to have to go to court, and you're going to have evidence. And that evidence you're going to have to lay out in front of a judge and say the reason they're being antisocial is X, Y, or Z. So you've got to have protocols in place to make sure that you are monitoring, recording, you're gathering evidence for that. And to me, that is going to be not just onerous on the landlord, but in a lot of circumstances, say in an HMO, where the antisocial behaviour is not necessarily them causing mayhem to the neighbours, but literally within the tenancy, and a lot of landlords, have helped their tenants remove a co-tenant who's been disruptive. I think that's going to be a challenge as well. But again, hard cases don't always make good law, but equally they don't occur very often either.
Yeah. Okay. So if you could give landlords one piece of advice for how to conduct themselves differently from the 1st of May onwards, what one habit would you change to make a big difference to staying out of trouble?
Communication. Make sure that now that if you haven't in the past, build up solid, robust communication avenues. I say this to letting agents all the time: build up a rapport both with your tenants and with your landlords. But for landlords that are self-managing, get that dialogue in place as soon as possible. It's their home after all, but it's your property, and you want to protect your interest and make sure that you are protecting your asset and your income. But that is their home, and this is now an opportunity for you to understand their rights, but also to understand that you're on their side as well, and that this is a partnership. It's not an adversarial situation, and it shouldn't get to that situation. So communication is important. Making sure that the boundaries are understood, that you are there to intervene and to make sure that you are dealing with these problems. Remember, okay, the powers are now being extended for local authorities, and they've got a raft of powers now, and the fines are eye-watering. And I can guarantee you, if you dig your heels in on a small issue, and the tenant gets the local authority involved, they won't just find one offence; they will find multiple. So you need to make sure that you deal with the little issues and stop them growing into a big issue. So if somebody says, makes a complaint and you don't deal with it, and they call in the local authority are going to find, well, you haven't done this, you haven't done that, you haven't done that. So make sure that communication and you deal with things as promptly as possible.
Okay. Just looking ahead to phase 2, the private rented sector database, the Ombudsman, the Decent Home Standards. What should landlords be doing now to prepare, even though those changes are further out?
Well, those landlords who are already experiencing local licensing, and that's an increasing number, but it mainly applies to HMOs. But those landlords that have never had to be subject to local licensing should now start to say, actually, let's line up our ducks. Let's make sure that we have everything in place in terms of compliance that we possibly can. So checklist out there to make sure that if you take a deposit, it's properly protected, you've served the prescribed information, gas safety is in place, electrical safety is in place, local licensing is fully complied with. These will all be parts parts of the database requirements. Now, between you and I've not seen this, and they're going to trial it out in the real world. Actually, I think Oxford City's been chosen as the guinea pig to go through this, because they've got universal local licensing. So their landlords should be a step ahead of a lot of other local authorities. But my understanding, it will probably start off as a self-declaration process, because there won't it won't interact with it won't automatically populate. So you'll have to go and tick boxes that you've got all these documentation, and then on demand prove that you have them. Ultimately, in the ideal world, these databases will start talking to each other. So literally, we'll just go on and register, and it will all populate it and check that you've complied. A bit like when you get your you get your DVLA license. It kind of checks. It knows you're insured. It knows you've got an MOT. It won't be as sophisticated as that to start with, but I think it will end up being that way. So again, make sure that when you're ready, that you've got all that documentation to hand, and that you understand what you have to do, the tick box that you have to actually comply with.
Great stuff. And finally, where can landlords go for reliable, up-to-date information on all of this? What source do you trust, and what would you steer people away from?
Right. So the number one place to go is the government has set out extensive guidance on their website. .gov, so you go onto the website and there is extensive guidance. It's like everything with the government. There's stuff, a lot to wade through. So who then could you go and get some reliable information? Of course, if you are really kind of unsure, go and get legal advice, but you're going to have to pay for that. In terms of, and to be fair, it's a lot of it is not that complicated. You need to get a solicitor involved, but you may well need to. So who else can give you advice? If you're a member of a local of a landlord association, the most obvious one, the NRLA, they're the biggest, 110,000 members. They have a lot of information on their website. We at the PRS are disseminating information. I have to admit, on our website, we have slightly less information than we have on some of our sister websites. So My Deposits, for example, has a lot of information on their website on all of these things, as does our sister company, Total Landlord Insurance. I do a lot of publicity on media. Right, so when you are looking at any of that information, okay, make sure that you double check and verify it, okay. Because we've got government approval, we don't put out anything that we think is controversial in any shape or form. But it is just advice. Where not to get advice, honestly, those forums that you might be a member of there, where everybody and anybody can put their 2 pence in. Anybody that promises you that there is a shortcut or a workaround or a loophole that they have discovered and you can do, don't trust that, because they are most likely not to be the way out of it. And literally, honestly, if you go down the pub or you're at your mosque, don't listen to Joe Blogs or Imran, who's been doing this for 40 years, because he's probably more ignorant about it than anybody and will give you the wrong advice. Make sure you verify, the advice you are getting, is the correct advice. Ultimately, refer back to the government's website or take legal advice if it's something really that you are concerned about. There are a few people out there that I trust, people like David Smith, who is an eminent lawyer. His advice is usually spot on. Another one called Suzanne Smith. She brands herself as the independent landlord. I trust her opinion. There's the Guild of letting agents. Susie Corolla. She's very, very knowledgeable. She trains letting agents in all of this. Julie Ford. There's a lot of people there that are giving very, very good advice, but double check it and don't take it as gospel.
No worries, that's great. Thank you. And thank you, Sean. You've shared that level of experience and insight. And I think everyone that's listening today has come away with a much clearer picture of what they need to do, and more importantly, why. So to give you a little bit of a break for the moment, I'm going to hand over to my colleague Roy, and he's going to do a very quick demonstration to see how that compliance that you've talked about can be, implemented practically. So Roy, over to you.
Sharing is not turned on. Can you do my sharing first, please?
Yeah, there you go.
Okay, so this is Landlord Vision. This is our software. This is the dashboard of Landlord Vision. And on here, we can get a quick overview of everything that is going on. So obviously, we've got some financial data on here as well, but we've got lots of other useful data. So we can see the status of our tenancies, and it uses expiry dates, so we can see what's about to expire and what indeed already has. And again, we can set up expiry dates for things like insurances, safety certificates, and all sorts of other compliance notices. And we can see what's coming up in terms of our expiries as well. And I can click on, let's say, my safety certificates, and I can immediately see that I've got one today, actually. So I need to make sure that that one's been dealt with. I've got some other ones coming up, and the contact of who to speak to them about. And we can add new ones, and we can remove things from here as well. So I can add. I've got a whole. Software comes with some default certificate types, but you can add in new types on here as well. And just click on the option under here, and that adds it. For your expiry date, you can also upload the document itself, share it with the tenants, which we'll come back to shortly. And you've got that in your system, and it will notify you when prior to the expiry in a few months' time. You can also track tenancies. These show fixed term. We'll be rolling out the periodic tenancies fairly soon, which won't have the fixed term on them. And within here, we can store more information. It's not the right one. Let's go down to Ben. You can got section for documents in here, so you can save documents, upload them to the tenancy, and you can even produce your own documents as well. We've got a whole legal documents section in here. We've got the tenancy agreement. We'll have the periodic agreement coming up shortly. Section 21 is on here, but that'll be going away as well when the new document comes in. And we've got what we call the rent increase letter. It's actually the section 13. When you run it, it says the section 13, which Sean was talking about earlier. And also in here, we've got our check-in and check-out lists. You've got a list of things that you can do at the start of each tenancy. You can tick these off and just make sure that everything has been done. Similar for checking out as well. Down the bottom here, we've got a communication section. You can use the software. We were talking about emailing out your government document. You can upload the document to here and to send out to all of your tenants at once. So if you've got everybody set up in the software, we can simply set a filter, show me all of my active tenants right to there, and then I can just select them all and write out an email, attach the document, and that will go out to everybody at once. Or you can do it as well for other things. Sean talked about just general communication. This is a good way of keeping in touch with your tenants and letting them know what they need to know. And also on the communication side, we have what we call the tenant service desk. So we have a tenant portal. You can invite your tenants to the portal. They can view lots of useful information, things like what their rent schedule is, where their rent schedule is up to. Actually, you can track all of that as well. You can share documents with them, and they also have a link to the tenant service desk where they can report and raise any issues that they may have. And they come into here. You can escalate those to other people if you have other people you work with. And you can even, if I go into this one, you can then convert those to a task or a work order and send those off to other people to try and get those resolved. And further, we have a calendar area. So on here, you can see all of your things that are due to expire, early warnings of safe certificates going off, and the safe certificates themselves will appear on here too. Got right to rents expiring, so you can track those expiry dates as well. Tenancies finishing, so you can see listed everything that's going on in calendar format, as well as the dashboard that we saw earlier. You can get all this stuff by email as well, so it's a really powerful tool. Tasks in here as well. Keep tasks of one-off things that you need to do, rent reviews and anything else that you need to keep a record of to remind you to do that. And again, it can notify you when that's due. And we've got a diary section in here too. So anything that you've done, any conversation communications you've had with your tenants, anything you've done with your properties, keep a record of it in a diary, and you've got it all stored for the future. And that's me. Back to Emmeline. You're on mute.
Sorry, apologies. I was just saying thanks, Roy. That was a really, really helpful walkthrough. It's one thing to know that you should be keeping those records, and quite another to see how straightforward it is, or it can be, with the right tools. So now let's jump into the questions and answers. Sean, we've had a number come in. Are you ready for them? And you're on mute too.
Fire away, I said. Yep, I'm ready.
Lovely. So the information sheets were really popular topic. So a few people are asking, you know, what is the document actually called?
Right. Okay. Oh, that's a very good question.
And where can they download it from?
You could download it off of the government website. Okay. Let me see if Google that. That's a very good question. We should really put a link in the in the chat.
I will say a couple of people have posted links in the chat.
Okay, fine. Okay,
yeah. Perfect.
Click on that.
And we'll when we send out the Q&A at the end or after the end, we'll put that in the Q&A as well.
Brilliant. Yeah, that would be helpful. Yeah, use the official one, not one that that somebody's made up. Go on. It's a bit like the right to not the right to rent, the how to let guide, which ironically you won't need to serve ongoing. So that's one thing that the legislation has freed you off from doing, because it's totally out of date, and there doesn't seem to be any proposal to do it. But it's exactly the same. You've got to serve the most up-to-date version. Okay, so if the government decide during the middle of May, which I hope they will not, that there's an error in it and they need to advise it, that you have to serve the most up-to-date one. But remember, you could only serve this now in this 1 month period. Wales had 3 months to do it, and their equivalent when they made their massive change, we've only been given a month. So this is something you've got to get on. If you haven't planned to do it, then plan to do it now.
Yeah. Okay. So following on again, if a landlord sends the information sheet by email, is it enough? Or does the tenant have to acknowledge receipt of it to count as served? And what happens if the tenant later claims they never received it?
Right. Well, that's always the problem with sending stuff by email. Yes, of course, put on a read receipt, because that can give you evidence that they have actually opened or even read it. However, you don't need to do that. If they have given, you are permitted to serve notices by email, and they have given you the most up-to-date email that they've got, okay, then it would be deemed to have been served. Okay, if it goes into their spam or into whatever, okay, you will be protected, but it is prudent for you to advise them. I would say you don't want them to even for there to be an investigation. So you can. This is about the pre-communication. So I'm going to serve you this thing. Then please check your email. It shouldn't block it, and they should make sure it's the most up-to-date one. So as long as you've done what you need to do in terms of legal service by email, then you're protected.
Okay, and again, this information sheet's very popular. Does the information sheet still need to be served if the tenant is already on a periodic tenancy?
Yes.
Yes.
Because
Okay,
it's
software.
change, you're informing about the the ongoing one there, because the old periodics will be as defunct as a fixed term.
Okay, and does that sheet also need to be served to the permitted occupiers added by addendum, or only to the named tenants on the original agreement?
Right. Okay. All record. It should go to every tenant. That's the advice. So anybody that's on that tenancy agreement should be served it now. So yeah. So not their children, but I would make sure that you serve it as widely as possible. I think there is the government answers that question on the Q&A. So off the top of my head, double check on that. But it is not just to the lead tenant; it has to be to all named tenants, and I think permitted occupiers. But I double check that one.
Okay. Who pays the cost when a tenant refers a rent increase to the tribunal? Is it free for the tenant? Couldn't they just escalate to delay the increase?
The answer is that the tribunal will charge them. Okay, but the government said it's not going to be a prohibitive charge. The answer to that is yes. I think there is an argument that why wouldn't they? And the reason that I would say for that is not everybody is as pernicious as we fear that they are. Because it is an intimidating process. There is a situation where you are, you have to appear and you have to provide evidence, and that's where the conversations, before are needed. You've got to be careful because you cannot, you cannot tell them the rent's going up without serving them the notice. But you can have a conversation, and that conversation is that, look, my costs have gone up. I'm going to think about rent. What sort of level do you, would, comfortable with, get an understanding of it, or do that conversation whilst you are serving the Section 13. Say, I'm wanting a 5% increase this year. Let's have a conversation. And most people will be reasonable if they believe that, because everyone knows things are going up. If they don't feel they're getting value for it, or that they think you're exploiting it, of course, they've got a right to challenge it. But I think you're going to have to get a regime now of kind of building up that trust with your tenants. But yes, technically, there is a situation there where you can, you can do it. Why would you not do it? One of the things I've spoken to the government about, and in Scotland they've got it, and they have a mediation process in Scotland where before you go, you take it to their tribunal. You can go and get it evaluated by this mediation service, and the government said that they're looking into this, but of course, if it's going to cost them any money, they're not going to do it. So yeah, we'll if the courts get inundated with these requests and appeals, then we might have another conversation in the future.
Okay. If a landlord uses ground 1A to evict for sale, but the property hasn't sold after several months, are they still blocked from reletting for the full 12 months despite best efforts?
Yeah, that's my understanding of it.
Okay.
Yeah, to be fair. Yeah. Yeah, that's the situation. Yeah, that you'll be in. So, I think that's why a lot of landlords are a little bit worried. There is you could attempt to try and sell a property if you were selling it to another landlord investor with an occupied tenant in it. So, I think that will become quite a common way as well. But yeah, it's a reality, and I think that's the situation.
Okay. When it comes to dealing with property issues and repairs, what's considered a reasonable timescale under these new rules?
A reasonable timescale. Well, it all depends on the severity of a request for what they're requesting. So a routine repair and stuff like that. What would I look at as being reasonable? 10 days for a routine repair would be probably reasonable. But if it's something like where water's been cut off, or a leak, or there's something that's kind of a health and safety issue, 24 hours in some cases. Now, very interestingly, just on a segue of that, because one of the other things, and the M word hasn't arrived yet there, but mold is a big issue that the government is trying to address as part of the legislation, albeit it's in their phase 3 of it, and that's introducing what's called AWAB's law. And AWAB's law is applicable now to the social housing sector, and it kind of rewrites a little bit about the understanding of damp and mold in property and who's responsible for it. It doesn't attribute the blame to the landlord for something like condensation led mold, only structurally, but it does put an onus on the landlord to be proactive in preventing it and dealing with it in a timely manner. That will come in as part of phase 3, along with the Decent Home Standard, which will probably prescribe more of this in law, but that's not due until mid 2030s. So this is a big drip kind of across the next 5, 6, 7, 8, 10 years that you're going to have to come up to speed with. So I would start looking at now getting in very robust protocols on your repairs, understanding that that if there's a threat to the property, to the tenant, to their health and to their safety, then you should deal with it as proactively and quickly as possible. If you delay it, then you're likely to end up kind of getting a complaint against you and with the ombudsman.
Okay, I'm just conscious of time. We're coming up to the hour now. Just one final question then. We've got several people asking about landlord registration. When does it start and where do landlords register?
So at the moment, my understanding is that they are rolling out in the next couple of months the trial in Oxford, and they are hoping to have the database up and running by the end of the year, but they are not committing to that. There will be it will be a website, and you will be directed to go on to that website. I believe that you will have to proactively go on to that, but there are big fines if you do not. So again, it's in development, so I can't say any more than that. I personally have not even seen the prototype yet. I've asked to see it, and they have asked some landlords through organisations like the NRLA, but there are other people who've had a preview of it. But it's like anything else. It will mean that you need to kind of act within the timescales when they announce that it's coming on board, and they probably will only give you a relatively short period of time to do that. So watch this space, but get your stuff lined up in the first place. I've spoken to a few, just from Landlord Vision's point of view. I've spoken to a few other tech companies that have tried to approach the government and said about integration. The government has not ruled that out from what I can hear, but they're not necessarily being proactive about it. It would be nice if you're using a text solution that all you have to do is push a button and everything gets uploaded. But I'm not sure that the government could cope with that at the moment. So it might be a bit more clunky than that. Lovely. But who knows? Some things the government do work. But be prepared.
We really appreciate you answering those questions. I mean, we had lots more come in, and I believe we're going to answer those and submit them, to everyone that after the event on the email addresses that they've supplied. So thank you very much for that.
Yeah.
Just a final few things before we go. Can Right. Yeah, hopefully you can see my slide again. Just 5 key action points for landlords. These 3 action points are really important, and you'll get a copy of these slides as well. The Act is enforced, the deadlines are real, and the good news is that getting on the right side of this isn't as complicated as it might feel. So a huge thank you to Sean for sharing his time and expertise with us today. I learned a lot, and I think everyone else here has done today. Certainly by the questions that we've had coming in, people have been gleaning a lot of information from what you've been telling us. Thank you to everyone for joining us today. You'll receive an email from us shortly with a link to the recording, the slides, and some further resources, as I mentioned. And if you'd like to explore how Landlord Vision can help you to stay on top of your compliance obligations, you can find us at landlordvision.co.uk. So that's it from all of us at Landlord Vision. Thank you so much, and have a wonderful rest of your day. Thank you.